India is a secular state, but many will agree that its secularism is strange in more ways than one. The state is expected to be neutral in matters of religion, and the secular culture is expected to entail equal respect for all religions. Critics of the manner in which secularism is practiced in India have assailed it as a euphemism for Muslim appeasement. But that apart, there is another problem. The reason why India's secularism is strange, to use a polite term, is because it is quite interventionist. Take for example the fact that thousands of Hindu temples in the country are under state control, particularly in many southern states. The administration and management of a place of worship by a secular state represents a contradiction, does it not?
There's a certain portion of secularism which says that the state will have no religion whatsoever. There's another definition which says that the state will treat all religions equally. It will be equally supportive or equally agnostic towards all of them.
It doesn't stop there. India's interventionist secularism also supports anti-conversion laws, which many argue are actually designed to keep Hindus within the fold, against attempts at conversions to Christianity or Islam. A formal change of religion would, as a result of these anti-conversion laws in many states, have to be declared before an agent of the state, usually a district magistrate, after checks and balances to ensure that the conversion is completely voluntary and in no way induced or coerced. Moreover, the constitutional validity of anti-conversion laws has been upheld by the Supreme Court, including in 1977 when they had been challenged. Here's another facet of this strange secularism. On more than one occasion, India's courts in a secular state have sought to interpret what constitutes an essential practice of a religion. It sought to do that in the Sabrimala matter in 2018 and examined Quranic scriptures in 2017 when deciding that triple talaq in one sitting needs to be done away with, or even most recently in deciding whether the wearing of the hijab was an essential mandate in Islam. Does it mark a deviation from secularism, or is the term so elastic that it is subject to multiple interpretations? The great personalities who were part of the Constituent Assembly and whose debates shaped the creation of our Constitution did not include the word secular in the original preamble. It was added to the preamble during the emergency through the passage of the 42nd Amendment of the Constitution. But even before the emergency, in the Keshavananda Bharati vs. Kerala judgment, a constitution bench of the Supreme Court upheld secularism as part of the basic structure of the constitution. This was reinforced in the Minerva Mills case in 1980 and thereafter in the S.R. Bommai judgment in 1994 and multiple other judgments. In November 2019, the Supreme Court in a landmark judgment resolved the Ram Janmabhoomi Babri Masjid dispute by ruling in favor of the Hindus. It paved the way for the construction of a Ram temple in what Hindus believe is the birthplace of Lord Ram. While the Muslims were given an alternate piece of land in a different part of Ayodhya. The judgment condemned the demolition of the Babri Masjid in 1992 as well, while reiterating on multiple occasions India's identity as a secular state. And in that judgment, it also made several references to the Places of Worship Act 1991 and said that the concerned act was an affirmation of our secularism. The judgment said, and I quote, "There is a purpose underlying the enactment of the Places of Worship Act. The law speaks to our history and to the future of the nation. Cognizant as we are of our history and of the need for the nation to confront it, independence was a watershed moment to heal the wounds of the past. Historical wrongs cannot be remedied by the people taking the law into their own hands. In preserving the character of places of worship, Parliament has mandated in no uncertain terms that history and its wrongs shall not be used as instruments to oppress the present and the future." Now, what does the Places of Worship Act 1991 really do? It was passed a year before the demolition of the Babri Masjid in Parliament following its introduction by a Congress government led by P.V. Narasimha Rao. It essentially orders a status quo on the religious character of a place of worship in India as of the 15th of August 1947 when we became independent. Simply put, any structure that was a temple, a church or a mosque or any other place of worship on that day in 1947 shall continue to remain one, unless the structure in question is an ancient or historical monument or declared as such, or has already been ruled upon decisively by a court before 1991, or if the disputed parties have agreed mutually to a decision. The Act made a special exception to the Ram Janmabhoomi Babri Masjid matter, which was left out of its ambit. There were many temples that had been destroyed during Islamic invasions as well as during Portuguese rule, for instance in Goa. The religious character of some of these temples was changed, with mosques constructed under Aurangzeb, as it is claimed in the Gyanvapi Masjid Kashi Vishwanath temple matter in Varanasi, or even the Shahi Eidgah Mosque Krishna Janmabhoomi case in Mathura. But many believe the Places of Worship Act comes in the way of Hindus seeking recourse through the courts to reclaim what they believe are their places of worship that had been destroyed, only to have mosques erected over them. So therefore, in a secular state committed to preserving the equality of all religions, is there an inequality inherent in its imposition that the religious character of places of worship cannot be changed even through judicial recourse?
When you speak of a right, in legal terms, it means it has a very specific meaning. You may have several wrongs which have happened in history or in your family life. Supposing somebody had squatted on your ancestors' land about 100 years ago. The law is that after 12 years, you cannot recover your property. There is something called the law of limitation. Now, going into history and saying that 400 years ago, this thing happened and that thing happened, to reverse it or to rewrite it or to forcibly capture it back, that is not the basis of a modern system of law. If you could convince people, buy out people, the law will not stand in your way. But to say that I have a right to forcibly recapture or to push aside other citizens of India, that to my mind is certainly wrong.
To be fair, the Places of Worship Act is a religion-neutral law, in the sense that even Muslims and Christians and members of other religions can stake their claim to places of worship that they have reason to believe were originally theirs, only to be converted to that of another faith against their will before 1947. But it would be fair to argue that those examples, if any, would be considerably fewer than Hindu claims of their places of worship being snatched away from them. The Places of Worship Act 1991 has already been challenged in the highest court, and it remains to be seen how the hearings proceed. More importantly, it would be interesting to hear what the ruling dispensation in India led by the BJP has to say about the Places of Worship Act 1991. The BJP is known to have walked out in 1991 when the Places of Worship Act was being passed in Parliament. What will its official stand be now? A court in Varanasi has given the go-ahead for a survey to be conducted, including videography, at the Gyanvapi Mosque complex following a petition filed by 5 Hindu women to pray at the outer wall of the mosque complex at a place they believe is the Ma Shringar Gauri Sthal.
I have with me the 4 Hindu women petitioners who have won a favorable verdict. They are celebrating at the Ganesh Ghat here at Varanasi, and you can see these are the 4 women petitioners who had moved the Varanasi civil court seeking permission for daily darshan of Ma Shringar Gauri and other idols engraved on the western wall of the mosque.
बहुत अच्छा लग रहा है, जो चीज़ हम लोग चाह रहे थे वही हम लोग के पक्ष में हुआ, क्योंकि सर्वे करवाना बहुत ज़रूरी था। वो कहते हैं हमारा, हम कहते हैं हमारा है, इसलिए दूध का दूध और पानी का पानी हो जाएगा। जब सर्वे होगा सब चीज़ सामने उभर के आ जाएगी।
हम लोगों को खुशी है कि जब इतना कड़ा जो है कि न्यायालय ने आदेश दिया है, तो इस बार हम लोग का सर्वे जिस तरह से होना चाहिए उस तरह से होगा। वहाँ फोटोग्राफी होगी, वहाँ वीडियोग्राफी होगी। अच्छा फील हो रहा है। न्यायालय ने अच्छा आदेश दिया है कि सर्वे होना चाहिए। अगर चाबी नहीं मिल रही है तो ताला तोड़ के सर्वे होगा, सच सामने आ जाएगा।
मेरा यही कहना है कि ये बहुत अच्छी बात है और प्राचीन काल से ही हम इस काशी भूमि पे है और वहाँ पे हमारी शिवलिंग है, तो अगर वो निकल आएगी तो ये तो हमारे लिए बहुत गर्व की बात होगी।
असलियत क्या है उसका सर्वे करके उसकी एक वीडियोग्राफी हो करके, और जब वीडियोग्राफी होगी तो अगर उसमें कोई छेड़छाड़ होगी तो अपने आप दिखेगा। और चूंकि सरकारी एक अमला जाएगा वहाँ पर, कोर्ट से नियुक्त जो लोग जाएंगे वो सरकारी व्यक्ति होंगे, वो क्यों छेड़छाड़ करेंगे? उसकी वीडियोग्राफी भी पूरी होगी। वो वीडियोग्राफी क्यों नहीं करने देना चाहते, सर्वे क्यों नहीं करना देना चाहते? छेड़छाड़ का मुद्दा ही बात गलत है। इसलिए जो सुप्रीम कोर्ट में तर्क लेकर के गए उनका तर्क गलत है।
This court order came after there was resistance on the part of the mosque management that did not want the appointed advocate commissioner to carry out the survey, even though the Allahabad High Court had given its go-ahead.
अजय कुमार मिश्र को कहा है कि नहीं ये रहेंगे, और दूसरे विशाल कुमार सिंह को भी उनके साथ जोड़ दिया है। दोनों लोग मिलकर ये संपूर्ण जो है कार्रवाई करेंगे, कमीशन की कार्रवाई करेंगे। कार्रवाई का समय प्रातः 8 बजे से 12 बजे तक होना है और 17 तारीख तक इसको जो है रिपोर्ट माननीय अधिवक्ता कमिश्नर को प्रस्तुत करना है।
This is a big victory of truth over all the kind of shadows which were created, because our specific stand was that in Gyanvapi case the lower basement has to be opened, and once the lower basement is opened, the truth will be out in front of the public, in front of the court, in front of the masses, and therefore the court has appointed now a 3-member advocate commissioner who will go and inspect and survey the premises and videograph and submit a report before the court. The survey has to start from 17th of May.
So there was an order of inspection and there the videography at the Gyanvapi Mosque complex, and also there was a controversy from the Muslim side that they wanted to change the commissioner, the court commissioner. So how do you see, was this a tactic, sir?
I think it was a delay tactics. It was a tactics to unnecessarily point some objections which have no basis in the eyes of law, and today all those things have been put to rest.
जिस तरह से मुसलमानों को जानबूझ करके परेशान किया जा रहा है, इसी तरह से यहाँ की मेजॉरिटी को ये दिखाया जाए कि जो मुसलमानों ने चीज़ें बनाई हैं तो इन चीज़ों का नाम ले करके उनको इकट्ठा करने की कोशिश की जा रही है। अभी लाल किले का नंबर नहीं आया। लाल किला मुसलमानों ने बनाया था, ऐसा थोड़ा कि और किसी ने बनाया था। झंडा उसी फहराया जाता है आज तक। उसको कब लाएंगे डिस्प्यूट के अंदर? तो ये सब चीज़ें जो है ना सिर्फ और सिर्फ पोलराइजेशन करने के लिए हो रहा है।
न्यायालय में सभी विश्वास रखते हैं, सभी देशवासी, सभी भारतीय विश्वास रखते हैं, और हम सब इंतज़ार कर रहे थे कि माननीय न्यायालय का जो फैसला आएगा उसके दिशा निर्देश के अनुसार सरकार कदम उठाएगी और वहाँ पर कानून व्यवस्था और शांति बनाए रखने का काम हमारा है। और मुझे लगता है सौहार्द के साथ में वहाँ पर सर्वे भी होगा और सभी लोग उससे स्वीकार करेंगे, सभी धर्मों के लोग, और ख़ास करके जो हमारे मुस्लिम समाज के वहाँ पर जो कमेटी के मेंबरान हैं वो भी उस फैसले के साथ जाएंगे।
कोर्ट का एक फैसला आया है जिसमें जो कमीशन की कार्रवाई है वो 8 से 12 तक शुरू कराने के लिए कहा गया है। वो कमीशन की कार्रवाई शनिवार को शुरू होगी। उसी कमीशन की कार्रवाई को लेके पक्षकारों को बुलाया गया था कि जो कमीशन की कार्रवाई है उसके दौरान सारे कोऑपरेट करें और शहर में शांति व्यवस्था बनाए रखें।
ज्ञानवापी मस्जिद को लेकर के वहाँ की जो कमेटी है, कहीं ना कहीं हम उनके फैसलों के साथ हैं। साथ ही साथ मैं ये भी कहूँगा कि जब 1991 वर्शिप एक्ट बना हुआ है तो देश को और देश की अदालतों को उस एक्ट का भी सम्मान करना चाहिए, क्योंकि कहीं ना कहीं सबके लिए एक सीमाएं हैं और उस सीमा का उल्लंघन किसी को भी नहीं करना चाहिए।
ज्ञानवापी मस्जिद को लेकर जो मामला चल रहा है वो बाबरी मस्जिद का रिप्ले हो रहा है, और बाबरी मस्जिद को लेकर जिस तरह से सुप्रीम कोर्ट ने बयान दिया है, जजमेंट दिया है, सेम वही होने जा रहा है ज्ञानवापी मस्जिद में भी, और इसमें कोई कुछ भी नहीं कर सकता। जो भी कानूनी प्रक्रिया है वो देश के कानून के मुताबिक है, लेकिन इस्लामिक रूप से वो मस्जिद थी, मस्जिद है और मस्जिद रहेगी।
First and foremost, I believe that the suit itself should have been dismissed right at the initial stage, because as long as the Act of Parliament remains, there is no relief that can be granted in a suit. In a civil suit saying that, look, I want to perform Hindu prayers in a Muslim place of worship, or vice versa. that I have a right to do so because 400 years ago something else happened, that is simply not part of law. To my mind, this is a feeling that people have which can be best addressed through mutual negotiations, through possibly buying the property or coming to some settlement in a different way. But to apply force would be totally contrary to the rule of law.
The Allahabad High Court has also called on the lower court to expedite all pending hearings related to the Krishna Janmabhoomi Shahi Idgah Mosque case and conclude proceedings over the next 4 months.
हाई कोर्ट का मैं बड़ा धन्यवाद दूंगा इलाहाबाद हाई कोर्ट का, न्यायालय का, कि न्यायालय ने स्पष्ट आदेश कर दिया है कि उसको एक समय सीमा निर्धारित कर दी है कि समय सीमा में उसको डिसाइड करना है और जितने भी प्रतिवादी पक्ष समय से उपस्थित नहीं हो रहे थे उनके खिलाफ एक्स पार्टी कार्यवाही शुरू हो जाएगी।
यादव साहब, एक और सवाल आपसे कि हमने देखा किस तरह से मथुरा कोर्ट ने रिजर्व किया था पिछली बार की हियरिंग में मैटर। उन्होंने ये भी कहा था कि फिलहाल इस हियरिंग में वक्फ बोर्ड के जो मेंबर्स थे वो मौजूद नहीं थे और बाकी की पिटिशंस को भी अभी फिलहाल जो है उन्होंने साइडलाइन कर दिया है और कहा है कि 4 महीने के अंदर अंदर जवाब देना होगा। तो क्या आप अब होपफुल हैं कि इस पर जल्द से जल्द निर्णय आ पाएगा?
मैं आपके माध्यम से बता देना चाहता हूँ कि माननीय मथुरा न्यायालय में 2 साल से बात चल रहा है और 2 साल से लोग अपना मुस्लिम पक्ष अपना जवाब नहीं दे पाया है। इसका कोई ना कोई तो कारण रहा होगा कि जानबूझ के टाल रहे हैं, मामले को लंबा कर रहे हैं। मैं पुनः धन्यवाद करूंगा माननीय उच्च न्यायालय को, उन्हें स्पष्ट आदेश कर दिया कि 4 महीने में आपको जवाब देना है और 4 महीने में मुकदमा डिसाइड होगा।
अच्छा, तो अब जिस पिटिशन पे सुनवाई होगी, it's going to be on the 13 acre of land that's expected. तो this is also going to affect the mosque that has been built in the area. आप क्या एक्सपेक्ट कर रहे हैं कि वर्डिक्ट किस तरफ जाएगी?
मैम, ये भगवान श्री कृष्ण विराजमान की जमीन है 13.33 एकड़ और पूरी उम्मीद ही नहीं, मुझे विश्वास है कि ये जमीन भगवान श्री कृष्ण विराजमान को वापस मिलेगी और ना वहाँ कभी कोई मस्जिद थी, ना हम लोग उस मस्जिद को स्वीकारते हैं, ना भविष्य में कभी स्वीकारेंगे। वो भगवान श्री कृष्ण विराजमान का मूल जन्म स्थान है जिसे तलवार की नोक पे छीना गया था और हम लोग कलम की नोक पे उसको लेंगे।
Where is all this leading to? Eventually, it will boil down to whether the Places of Worship Act 1991 should remain or be withdrawn. There are those who believe that it could be a recipe for future instability if that really happens. How far really does one go back in history?
Well, you can't fix everything in history, but the very significant sentinels which are there, I think instead of starting a fight about it, 2 communities should sit down together, things that mean a lot to you and things that mean a lot to them, whichever way it is, the 2 parties should sit down, and if something means so much to somebody, they must come to a compromise and fix those historical wrongs, because if you don't fix them forever, this resentment against each other will continue. In the nation-building process, it's very important that different communities are not in confrontational mode. If that needs to happen, it's important where there is a lot of pain, some balm should be applied. This is what I would say. But both the communities should come together and arrive at this rather than simply fighting it out all the time, because the fight doesn't cost either this community or that community. The fight costs a lot for the nation.
Can Hindu concerns and claims be brushed under the carpet? Will there be a compromise where 2 or 3 prominent sides are adjudicated on and the others left alone? Well, one will have to wait and see.
This is an unnecessary debate now. What I would say is 2 or 3 iconic places, if you settle, the rest of it you must leave it, because if you could not protect it then, now you're talking about recovering, then what is the point? If it meant so much, we should have protected it then. Unfortunately, we could not, all right, for whatever reasons. So you cannot rewrite history. But at the same time, very significant iconic places, when it means so much to a given community, I think there should be some give and take between both of them and come to some kind of settlement.